is the first of what we hope to be a series of quarterly legal hotlines for the American Society of News Editors. And I'm Kevin Goldberg, ASNE Legal Counsel. This is intended to be an interactive experience, so we want people who are watching live right now to try to reach out to us with questions. I'll explain how to do that in a moment after I give a brief overview of what we're going to be doing for our time here today and what the legal hotline is generally. So what I'll talk about today is give an overview of the legal hotline generally, what it's been and what it will be, how you can use it going forward. Talk about some of the work ASNE has done in its advocacy and First Amendment area recently, and then talk about some trending issues that I'm seeing around the country that maybe people need to start considering. What I'd love to do is hear from you as soon as possible in this process. These conversations are always supposed to be interactive, and the more of you that are watching live and want to ask questions live will hopefully make for a more interesting session and generate some follow-up questions. But if you're not watching live and you're tuning in later, you can always follow up, as we'll talk about in a minute, by asking questions to the Facebook page or the Twitter feed. Those are both ways that you can do this, that you can interact with me during this session if you are watching live. So again, this is the new and improved ASNE Legal Hotline. Thanks to the Charles Koch Foundation and the Excellence in Journalism Foundation, Ethics and Excellence in Journalism Foundation, for helping us keep this hotline not only up and running, but improving on it. I'd like to give a warm welcome to our friends from the Lion Publishers Association, the local independent online news publishers association, who are now able to take advantage of the ASNE Legal Hotline in a partnership between ASNE and Lion. And remember that while this is a public session that we're doing today, for the most part, the Legal Hotline is a member benefit offered to ASNE members and to Lion members. We really do think it's something that's valuable to you, and we want you to take advantage of it. What this means is this is sort of a combination. The Legal Hotline going forward will be a combination of things that are public, semi-public, semi-private, and entirely private. And you can choose the level of interaction that suits your needs. The public event would be this hangout that we expect to have quarterly. And again, I'd love to have it be sort of a very live and interactive session. Semi-public would be, for one thing, a convention event we're going to be doing in Austin at the News Leaders Conference that'll be held Wednesday morning at 10:30, Wednesday, September 12th at 10:30 a.m. And it's a live legal hotline. People in the room can come and ask questions. I will do my best to answer them. And hopefully what we're going to do there is generate a conversation around meaningful topics of the day. There will be hopefully the chance to do this at other events, smaller events, regional events like the Emerging Leaders Institute, which I think would be very valuable. And finally, of course, as I said earlier, we do have the closed group Facebook page. It's only available to those who have asked to be invited and have been approved to join, where we can really have some of these conversations and where you can ask questions today. And hopefully Paul will then forward them on to me as they come. Now, the private is, if you're not comfortable asking a question on the ASNE Legal Hotline Facebook page, you don't want to ask a question publicly on Twitter, I welcome your questions directly to me as necessary. You can either email them to me directly or call me directly. You can email me at goldberg@fhhlaw.com or call me at 703-812-0462. If you're an ASNE member or a Lion member, I'm happy to answer your question. What does that mean, though? What that means is I'm not giving legal advice through the Legal Hotline, despite the name. I'm not your lawyer. I'm the lawyer for ASNE. And really, as such, unless you and I have an individual attorney-client relationship, I can't give you legal advice. It means I can't really, for instance, engage in pre-publication review of a story. I can't act on your behalf to tell you whether a photo that you want to use is fair use, or a clip of music, or a video. What I can do is talk through issues with you to give you a better understanding of perhaps whether you need to hire a lawyer. I call the legal hotline that I do for ASNE and for other organizations in a similar manner an early warning detection system. Once we talk, you will know whether you sort of have a good feeling about where to go next, or whether this is one of those situations in which you may need to actually go out and spend money on a lawyer. So with that in mind, again, I'm always willing to take questions from people who send them in. You can go through the @NewsEditors Twitter feed or through the Facebook page. You could also, I suppose, still email me if you'd like. Or you can email ASNE and hopefully they'll forward the question on to me. And so with that, though, let's do a quick review of some of the efforts ASNE has taken on behalf of its members and the industry generally over the last, say, 2 months. First and foremost, in my mind, because it's actually happening today, is actually not a free press issue, and something I've had to talk about or had to teach myself a lot about in the last 3 or 4 months, which is the overhanging issue of a tariff being applied to the importation of uncoated groundwood paper. Not the sexiest issues in the world. I mean, I like to think that I do some really fun and exciting stuff working on behalf of journalists for ASNE. But this is definitely amongst the more sort of niche issues and one of the more mundane, but certainly not an unimportant issue, because today, as we speak, the International Trade Commission is holding a hearing to determine whether interim findings by the Department of Commerce and the ITC that there should be duties applied to the importation of uncoated groundwood paper from Canada, on uncoated groundwood paper from Canada, duties which have already been applied at the border, should be made permanent or not. And this could increase the price of newsprint and therefore the price of publishing a newspaper by as much as potentially 30%. The ramifications are being felt around the industry as we speak. We've seen a number of editorials. You can go to the STOP, STOPP coalition website, of which ASNE is a member, and see some of the editorials and stories that have been written about this, which explain the issue in great detail. We've been a member of this coalition since it started, and we've been trying to get information out to ASNE members and others who are interested in learning more so that they can contact their congressmen and senators, ask their congressmen and senators to either weigh in with the ITC or to support something called the Print Act, which will at least put a moratorium on the duty that's being applied at the border, which again is raising the price of newsprint and causing people to, as we've heard, lay off workers or see other areas of, the other opportunities to print their papers perhaps in other areas and elsewhere. And I don't want to go into too much back history of this, but it's really all about the actions of one paper mill in the Pacific Northwest called NORPAC that has claimed that there's what we call dumping and unfair subsidies that are being given to Canadian paper mills, Canadian paper manufacturers that are affecting its ability to compete in the marketplace. NORPAC is the only paper mill that is making this claim to the Department of Commerce and the International Trade Commission. In fact, every other mill and the industry at large is not supporting this. It's something that, again, we hope to be able to work on. It's not something that usually people are aware of or expert in, but it's something you should be aware of. And I urge you to learn more and ask me questions if you have them. On a more free press, focused issue, some of the things we've been working on lately have been support for individual journalists. We've actually been a part of letters of support for and even amicus briefs in support of 3 different journalists, 2 of which are in the United States right now, 1 of which is in Egypt, who have been pressured, punished, criminalized, facing deportation hearings, or worse, for basically being journalists. One of those is Emilio Gutierrez Soto, who some of you may be aware of, has been in deportation hearings and is before the Board of Immigration Appeals, despite the fact that he's won a number of awards and has actually now been given a fellowship in Michigan, should he have the opportunity to use it. We've joined followed the lead of the National Press Club in garnering support for Emilio Gutierrez Soto and his son, who both are here basically after fleeing Mexico to come here and do work because they feared for their lives in that country based on his work as a reporter there. He's now faced deportation hearings, and we think that he's being unfairly targeted and should be granted asylum in the United States. A similar situation was encountered by a reporter in Memphis named Manuel Duran, who left El Salvador after covering government corruption and especially the way the government has been working with illicit organizations in that country. He fled that country after receiving several death threats, lived in the United States while he had a pending immigration proceeding going for about 11 years. He started his own news publication here. And yet on April 3rd of this year, he was arrested under the charges of disobeying a police order and blocking a highway as he was covering a protest in Memphis, Tennessee, his now hometown. He was arrested and put in jail and released 2 days later because the charges were all dropped. Now, the interesting thing is he was not released to the public. He was released from police custody to ICE custody. He's written very critically about Memphis Police Department, and he thinks, and we think, that he was subjected to a lot of he was targeted for this arrest as a pretense to perhaps start an immigration deportation proceeding against him. We joined a letter of support that was drafted by the National Association of Hispanic Journalists and an amicus brief that's been filed on his behalf with the Board of Immigration Appeals by the law firm Ballard's Bar. Finally, there's another situation where a photojournalist in Egypt was arrested after taking photos of protests in that country and was actually facing the death penalty. Again, we joined the National Press Club in support of the photographer commonly known as Shawkan, Shawkan, and his rights. And this is just sort of give you an overview of what we're trying to do at both the micro level and the macro level, where we take on larger cases in places around the country. One of which that happened in the last couple of years was joining an amicus brief that was filed in Baltimore in opposition to a non-disclosure agreement entered into by the Baltimore Police Department and people that had reached settlements with. So people who had sued Baltimore police for, among other things, police brutality or illegal arrest, in settling their cases, were told that they needed to enter into a non-disclosure agreement, which prevented them from speaking about the cases. Of course, reporters in Baltimore and elsewhere need to talk to these people to get a better view of what policing is like in the city of Baltimore right now. And so we said that this non-disclosure agreement violates the First Amendment. We joined a brief drafted by the Reporters Committee for Freedom of the Press, who's someone that thankfully reaches out to us quite often. We're grateful for these opportunities and invites us to join briefs that they've written in support of free press issues. Next up is support for school journalists in Prosper, Texas. We joined letters that have been drafted by the Student Press Law Center in support of what has actually been an award-winning high school newspaper down there. And this is part of ASNE's commitment to help student journalists become professional full-time working journalists and help the next generation. Despite winning a number of awards, these journalists have been subject to really a heavy hand of censorship by the administration and had their newspaper advisor's contract was not renewed at the end of the last school year. So we joined an effort there as well. Now, higher in the news, and again, on a more macro level, I'll talk about it both here in terms of the trending and in terms of the trending issues that I'll go to next, was, of course, when the New York Times reporter Ali Watkins had her records seized, her communications and email records seized by the Department of Justice. We have gone through a number of avenues to protest this decision, both an ASNE statement, a statement made as part of the News Media for Open Government coalition that we're a part of. ASNE is one of the member organization of News Media for Open Government, and you can learn more about that organization at foropengov.org. And also joining again a statement drafted by the National Press Club in conjunction with PEN America, which asks specifically for an explanation from the Department of Justice as to why they have failed to follow their own voluntary guidelines in issuing subpoenas to the media, guidelines that were updated based on conversations between the Department of Justice and news media organizations. I was at a couple of those meetings 5 years ago when the Obama administration, under Attorney General Eric Holder, had taken a couple of actions that were really threatening to the media. Seizing third-party communication, email records of reporters, and actually naming a Fox News reporter as a co-conspirator in a leaks investigation. And after some, we thought, pretty productive conversations that may have righted the ship, we have now seen what might be a disregard for the admittedly voluntary guidelines that apply to the Department of Justice and its ability to subpoena records of the news media. Finally, most recently, just this past week, you may have seen that the Los Angeles Times was subjected to a really strange order from a United States Federal District Court judge to unpublish portions of an article it published last Saturday, July 14th. This arose out of a plea agreement that was entered into by a local law enforcement officer in Glendale, California, who eventually pleaded guilty after an investigation to basically taking bribes and lying to federal law enforcement officers about this. When the New York, this plea agreement was ordered sealed by a United States Federal District Court judge in the Central District of California, the Los Angeles area. And though it was ordered sealed and was supposed to be sealed, somehow it made its way into the public record. And a reporter from the Los Angeles Times saw the plea agreement, decided to publish the plea agreement. He was asked not to, the paper was asked not to by the defendant's family, They considered the request, but decided that this was important enough that people needed to know about it in the community, and they published it. The defendant went to the judge and asked for a temporary restraining order and an injunction against the paper. And the judge, flying in the face of a lot of precedent, granted it, effectively creating a prior restraint on the Los Angeles Times' speech. He didn't seek to punish them. He simply said, you must unpublish this article, a classic prior restraint, and an odd one, given that the horse is already out of the barn. I mean, effectively, it would, I think, at this point be impossible to unpublish that information, but that's what he told them to do. The Los Angeles Times is appealing that order on an emergency basis to the United States Court of Appeals for the Ninth Circuit. And again, we have joined a letter that was drafted by the Reporters Committee for the Freedom of the Press that we, ASNE, has joined onto. I see that we have a question here. I'm going to finish this one part, and then we'll go to a question before I talk about trending issues. I'm really excited to see something come in. But just to finish this thread of ASNE's advocacy, what can you do to get involved? Because I'm inviting you to reach out to us when you have issues. This is what we're here for as a membership organization for ASNE members. I think you should seek to become involved with the ASNE Freedom of Information Committee. When you get to Austin, if you're attending the convention in Austin, seek out ASNE officers, find me. We'll tell you how to get involved. We can always use people that are willing to be our eyes and ears on the ground around the country and willing to participate in what we're trying to create as an emergency first responder program within ASNE to help us get statements out, get letters out, get advocacy out on a quick, rapid fire basis when things happen. It's something that we learned was something we needed to do, especially after the really tragic shooting at the Capitol Gazette. In Annapolis, Maryland. How do we make sure that we have a response once we have all the facts in our hands, ready to make a statement on behalf of ASNE? It's not limited to extreme situations like that, but it is also something we need to be better at when we have something in a legal or free press sense that happens. If you see an issue that needs attention and you think ASNE can get involved at the state or local level, that would be great. We're willing to do that. We try not to inject ourselves into purely state or local controversies because every state has, among other things, a state press association, usually has a state open government coalition, and we don't want to be the outsiders coming in and telling people what to do. But if you think a situation exists where we could lend our voice, or if you just want to bounce something off me to see that whether it's something I see trending nationwide, or you think that there's an opportunity for ASNE to join an amicus brief. We generally don't have the capacity to write them ourselves, but we're happy to join if somebody is willing to write it, or a protest letter. We're happy to jump in and join if it's something that's going to have nationwide impact, or we think we can make a difference. Then yes, please reach out to me. Again, goldberg@fhhlaw.com, 703-812-0462, and we can talk about what ASNE can do to help you. So now, before I turn to trending issues, I do have a question that I see that it's come in, and I'm really happy about that. Can the court subpoena for text messages over Facebook or WhatsApp text messages? So basically what you're saying is if a reporter has an ongoing conversation over Facebook with a source, or over WhatsApp, or even by text message with a source, could the court issue a subpoena to get access to that? If I've got that wrong, please, whoever asked the question, follow up. But I would say absolutely they can. And it's really no different than going to, say, Google and asking for your email conversations with a source, which is why I think one of the things people need, and we would urge that again, if a court does it or a U.S. attorney does it, well, it's not really the court that will demand the subpoena in most instances. Someone will apply to the court and ask them to issue a subpoena seeking these records. And generally we would hope that the court would take this under consideration and only issue the subpoena in the most limited situations. Of course, there are state shield laws that are going to apply. But as I always say, one of the problems is a state shield law only applies if you are in a state court. So if you have a federal prosecution or a federal investigator, federal law enforcement like the FBI, who goes to the court and seeks the subpoena, then the state shield law or the state reporter's judicially created reporter's privilege won't apply. And I think that it's clear that now there are any number of communications methods. It's not just about email. It's not just about phone calls. It's not just about your notes. It is about conversations that happen through other things like instant messenger, WhatsApp, or Facebook. And I think one thing that needs to be done is journalists need to understand that they need to find better ways to communicate with sources that they really want to keep confidential that don't involve electronic media with a permanent record. So yeah, that I would be very careful using Facebook to communicate with the source. I'd be very careful using WhatsApp to communicate with the source. I would be very careful using a text message on your permanent phone, your permanent mobile phone, to communicate with a source. This is the reason that many reporters turn to burner phones at certain times when they need to, and that may not even be enough. I mean, in the most sensitive situations, you need to go completely old school, face-to-face conversation, cloak and dagger, if you really want to make sure that you're not leaving a trail that could get you and your source in trouble. So I hope I answered that question. As I wait for any more that might come in, and I'm kind of looking away to scan the screens here that we have and see where new things might come in, I'll turn to some of the issues I'm seeing trending at the especially the local level, but overall throughout the industry. Honestly, number one that I'm worried about a lot right now is still not a free press issue. It's copyright. I've told a number of people, I was doing a presentation on copyright at a conference last week, and I said, one of the biggest things that's changed in my work over the past 23 years, is that I do less defamation kind of pre-publication review and clearance than I do copyright clearance, and I deal with certainly more copyright infringement demands than I do ever, demands that we're going to sue somebody for, or letters that threaten a lawsuit for defamation. And I think this is really down to new technology. It's easier to find content on the internet, and it's easier to instantly publish that content on the internet where it's going to be found by others. There's also the idea that a sort of misunderstanding of copyright that leads to this, though it's getting better. I mean, I feel like we've bottomed out of the area where we had a generation of people entering newsrooms that grew up on the internet, grew up feeling that things were freely intended to be shared, and they didn't really have a good grasp about what copyright really means. I think we're coming out of that. I think people entering newsrooms do have a better appreciation of the importance of owned content, of copyrighted content, and getting permission to use it. But I still think there's a lot of work to be done. There are obviously a lot of trolls out there that will take advantage of any mistake people make when they use copyrighted content without permission. And so what I think we still need to do is a lot of, as leaders, what you need to do is make sure you have some kind of training in place for your new hires, for your digitally focused hires, for your interns. Even if it's an hour-long webinar with someone that you bring in a lawyer, someone like me or your local counsel, and ask them, could you do an hour-long webinar for our summer hires or our summer interns? I think that's going to play a valuable role going forward, and it's going to be a great refresher for people who've been there, because copyright does change a lot. Two things we've seen lately are two big cases that I think are still at the lower level, but very important and could do a lot of damage to the way you do business going forward, or protect your content going forward, if they're allowed to stand. One came out of the Southern District in New York earlier this year. It's called Goldman versus Breitbart. Breitbart News was sued by someone who took a photograph. It's going to take a little bit of a second to get here. Someone took a photograph of Tom Brady in the Hamptons, ready to meet, apparently 2 years ago, with Kevin Durant as part of the Boston Celtics pitch team to try to get Kevin Durant to come to Boston, when he eventually, of course, signed with the Golden State Warriors and changed the balance of the NBA for years to come. This was tweeted. This person took the photo, tweeted it out. Eventually it was retweeted, which is all fine. But then somebody embedded the entire tweet from Breitbart, and some other sites did this as well, into their own story. So now you have used embedding technology to put it into their own site, which we all thought was perfectly fine, just like embedding a YouTube video onto your own page. Because the original content still resides on the original server, on YouTube or on Twitter. So people have said, there's nothing wrong with this. This is not a copyright violation, and everybody's doing it. Except that in this case, Goldman versus Breitbart, a U.S. District Court judge in the Southern District of New York said, no, it actually is a copyright violation. And you shouldn't be embedding in a way that makes it unclear. Now, there's a little catch to it. It's not that all embedding would be necessarily bad, but embedding a tweet in a way that makes it unclear as to the source of that tweet, or it creates an affiliation between your publication and the person who originally tweeted out could be problematic. So I think you need to watch this. It's already being appealed to the United States Court of Appeals for the Second Circuit. But if upheld, it is something you will need to be aware of, and possibly change practices in terms of the way you're doing business. Finally, there's a case involving fair use, which I think is going to certainly be overturned. It's here in Virginia. And then I do see I have two questions that came in. Fair use case called Brammer versus Violent Hughes Productions. In this one, a photograph was taken of the Adams Morgan neighborhood in Washington, D.C., and somebody used the photo as part of their website for their film festival. And when sued for not getting permission, defending themselves, arguing fair use. I would have believed this was a classic not a fair use situation. Somebody took a photo, somebody is using it to promote their admittedly nonprofit event, but to promote their event nonetheless, and didn't pay the photographer. And yet, overall, in the balance of things, a judge sided with the film festival and said this was fair use. And I think that, again, also overturns things in a way that, a lot of people in my world were like really shocked to see this be an issue, be a decision in this case, because they think it's going to make it a lot more difficult for photographers to protect their content. On the balance of things, I'm sure a lot of people out there saying, hey, this is great. We get to use, from amongst the people listening here, we get to use content more freely. But I would not rely on this case, and I would be a little scared of this case in terms of what it might do to the balance of fair use. So now let me turn to the two questions I've seen come in. And I think because we got a little late start, I'm willing to stay on as long as people want, but probably maybe we're going to go 12 to 12:45. Maybe we go to at least 12:50 or a little beyond. I'm even willing personally to give a cutoff at 1 p.m. if we don't get any more questions. What information should you try to include in a FOIA request so the agency has the lowest chance of wriggling out of it or giving you the runaround? Yeah, this is a valuable question because you have to kind of always ask, do I write broad so that they don't have any chance to say, well, you didn't specifically ask for this, or do I write narrow to try and argue that people should understand specifically what we're going to gain access to, what I need access to. My advice is I'd always go narrow. I would always go slightly narrower. The broader the request you have, the longer it's going to take to get answered, the more it might cost to get to eventually, if once fees kick in for you, to get that answer. And finally, there is a chance that a FOIA officer could wriggle out of this because they're going to say that the request is too broad to reasonably allow you to allow them to produce the records you need. My advice, and my advice to myself and my advice to people that I'm working with on drafting a FOIA request is treat a FOIA request like a story. Don't use it as a fishing expedition. Do your research beforehand, write the request up, set it aside, and then come back to it later. I think you need to make every request time limited in some way. I think you need to make everything sort of person limited or record limited in some way. So those are the big three. Make sure you have a clear delineation of the time period from which you want the records. Make sure you identify the records in type and specificity as much as you can. I would go more specific. And make sure you, especially for things like emails, you identify the people who are involved in the conversation. Those are the big three I'd look at and try to be as specific as possible. If you don't get back what you need, then you do go back out and try to find something else later on. Number two, is there any way to call an agency's bluff if they come back to you and say they're going to charge you an ungodly amount of money for a request due to man hours or legal consulting or whatever? A big university around here will tell us it's going to be $500 or some large amount. We want to know who says, but we don't have anybody to fight, so we drop it because we don't have any money to pay. This kind of feeds into that initial question as well. They're both sort of similar. You get a response like that from an agency that is, this is too broad, or this is going to take a lot of time, or this could be too expensive, then I think you shouldn't drop it. What you need to do is go back and have a conversation with the FOIA officer to figure out what you can get with a reasonable amount of money, a reasonable amount of fees. I think what's interesting here is, again, for the most part, now this was unclear, but I'm going to assume that since you filed it with the university, it was a public university, which means you're filing under a state FOIA law. And another sort of reason I don't give legal advice through the through the legal hotline is I'm not an expert in the laws of all 50 states, so I don't know what this particular state's rules are regarding fees. But as a member of the news media, you should be exempt from a good portion of those fees. And so I think you need to do what you can to make sure they understand you're a member of the news media, to accept the exemption to the greatest extent you can. And if it still comes back with a rather large fee, then you can use that as a conversation with the office, the FOIA office, to figure out what you can get as quickly as possible and as cheaply as possible. I even would argue that sometimes you should do some pre-filing due diligence to try to have those conversations. And I do that as much as possible here. I was working with an associate here at our firm who was filing a FOIA request on behalf of a client. And it had about 4 different record type components. So we want emails from this, and this, and about 6 different years. And he said, is this going to be too broad? Is this going to be too complex for us to get anything that we want? And I said, it might be. So, but maybe the issue is structuring the request. Why don't you just call up the FOIA office and say, this is what I'm looking for. How can you help me help you, as I like to say, get to what I need, and make it as painless to both of us as possible. So I hope that answered those 2 questions. I welcome a follow-up if necessary, or if I didn't get to those answers. And so I mean, fees is probably one of the big 5 issues I see as we kind of move forward and into some of the other trending issues. Fees are definitely one of the issues I see around the state and local level, as something that is problematic. Especially as you get more to the local level and you have more local publications that don't have big budgets. One of the things I think I'm seeing trending around the nation is a fight over mandatory legal fees, if you need to go to court. I realize that if you have to go to court, for many of you, the battle is already lost. But if you have the ability to hopefully get your legal fees guaranteed if you have to take up that fight, then that's a big game changer in my book. And I think that if you're in a state that has this issue before its legislature now, either, it should be the default. Every state should have this issue. And if you need to check, and I think that's one thing you should check on your state FOIA law or public records law, is to see if that's an issue. If not, or if it's being threatened, you need to fight out and make sure that, speak out and make sure that this right gets preserved. In terms of, you brought up universities. I think FERPA is still a big issue at the state and local level that we're seeing around the country. People in communities that are fighting school districts or universities for information are continually running up against the FERPA roadblock in a way that's being over-invoked, much like other exemptions we see at the federal and state and local level around the country when they file FOIA requests. I would say that this is something that you should not just give up on in the face of a rejection. If you get a rejection under FERPA, you need to look really closely or try to understand what FERPA really does allow a school to exempt, or in fact, in some cases requires a school to exempt for fear of losing their federal funding, or whether they're using it as simply a smokescreen to try to not give out information. Because 9 times out of 10, maybe not that high, certainly 7 times out of 10, I believe that they are using FERPA as an excuse to not give you the records you deserve under a state public records law request. They're using it for things that are well outside the definition of educational record, which is really supposed to be limited to things that deal with classroom issues and grades, things like that. A couple of other issues that we're seeing around the country, obviously, are access to people. This is something that bothers me. It's something we see at the federal level, increasingly across agencies. It used to be just something you would see at the intelligence agencies. Now it's almost all of the health science agencies, science-based agencies. Reporters need access to people who know what they're talking about, subject matter experts, and they're not getting that access. And we've been working a lot with various journalism organizations, the Society of Professional Journalists, and most recently the Society of Environmental Journalists, reaching out to science-based agencies and saying, look, we can't be forced to go through public records, the public information officer. We can't be forced to go through public affairs. We can't be forced to get the political message. We can't be forced to talk to these subject matter experts only with one of their media handlers standing over them and watching what they say. We want to be able to talk to people who know what they're talking about, to get the real story, to get valuable information that allows us to give informed reporting to the public. And we're seeing this, again, not only across agencies at the federal level, but we're seeing it now move down to state and local agencies as well. And it really needs to be stopped before it starts at those levels. A couple other things in news gathering. what we're seeing here again, one of the things that I referenced earlier is the subpoena for the records, the communication records of New York Times reporter Ali Watkins. That was problematic. I think what I'm starting to feel now is it's more problematic that after every media organization in the country, a ton of media companies around the country have reached out and demanded an answer, an explanation, there's been just radio silence from the Department of Justice. Again, these are voluntary guidelines that apply to their behavior. But I expected more. I expected a bigger commitment to free press. I don't know why I expected that right now, but I would expect if anyone is committed to free press, they would have answered, the question of what was the process used, why was the process used in this regard to get information from to subpoena information, were all the proper channels followed, and what can be said to assure us that this won't happen again. And we really need to be vigilant about this and hold U.S. attorneys' offices, the FBI, the Department of Justice, all accountable in making sure they follow their own voluntary guidelines. Finally, just to wrap up, I'm going to give you sort of the 2-minute warning. I'm going to go through 2 more topics, and if we don't have any more questions, we'll call it a day. Again, inviting you to follow up with me afterward as you need through our Facebook page, by email to me at goldberg@fhhlaw.com, or by calling me at 703-812-0462 to discuss any questions you may have. 2 more issues we're seeing. Threats, obviously, to news gathering in the public sphere. We continue to see reporters arrested or threatened with arrest as they cover public events, as they cover protests, as they see an arrest occurring on the street. I don't think it's helpful that the Department of Homeland Security just put out sort of a public alert saying this is an activity that's considered suspicious behavior. People who are photographing government buildings, walking around photographing government buildings is suspicious behavior, and that falls into the if you see something, say something category. Because as we know, photography is not a crime. Photojournalism is not a crime. And when we see something by this from the Department of Homeland Security, it's threatening to free speech. People are allowed to take pictures, yes, even of government buildings, in public space. And when they put out this message, you need to be worried not just because it's an affront to the First Amendment, because it makes it more likely that someone will come after your photographer and try to give them a problem or even arrest them for something they are legally entitled to do under the First Amendment. And I think this is being underplayed. I think people need to speak out about it. I think people need to counter this by getting the message out as well, perhaps through your papers or otherwise, to say, no, this is faulty information. And this threatens our ability to give you, our readers, information about the public and see things for your own eyes, with your own eyes, as to what's going on in your local communities. Finally, we're seeing an eroding of protection for anti-SLAPP around the country. You have a lot of very strong anti-SLAPP laws. This is one of my personal crusades. If you're not familiar with an anti-SLAPP law, SLAPP stands for Strategic Lawsuit Against Public Participation. Anti-SLAPP is a statute that gives protections to defendants who face frivolous lawsuits designed simply to shut them out, primarily threats of defamation that the person who's threatening the lawsuit understands is never going to be successful, and is only threatened or filed to get you not to say something or retract your statement. These laws not only make it easier for you to defend yourselves and streamline the process, but sometimes offer you the very valuable ability to get your attorney's fees paid for if the person actually takes you to court. Unfortunately, while we see these laws in about 30 of the states around the country right now, there is no federal law, which is now creating a big problem because more and more we're seeing courts saying that these state anti-SLAPP statutes do not apply in federal court. And that's a big problem because a potential defamation plaintiff will just simply file in federal court their frivolous lawsuit instead of going to state court. And they found an end around the state anti-SLAPP law. The 2 ways we need to, one of the things we need to do then is hopefully find another stalwart supporter in the United States Congress for an anti-SLAPP law and continue to motivate ourselves and the rest, and everybody else to protect free speech by supporting these laws. So again, that brings me to the end of the legal hotline today. We'll be back, I think, I don't think we're going to do another Hangout quarterly because the next one is scheduled is 10:30 a.m., Wednesday, September 12th. I'll see you in Austin. Until then, please feel free to send me questions if you want them to be private at goldberg@fhhlaw.com or 703-812-0462. or use the Facebook page where hopefully we can have a broad discussion about issues and others can join in with their own experiences. Thank you.